Good evening. My name is Clifton Williamson Jr. I am the owner of Parable Kingdom LLC. And today, what I'll be doing is going over some information about copywriting your work. This is another episode of Liberating Intelligence, copywriting your work. So as you can see, this episode that I have up is copyright.gov. And what this is the copyright law of the United States, Title 17, Chapter 1. So what I'm going to do first is go over section 102. I'm going to read it and break it down. And what it says is copyright protection subsists. So let's just start right there. Basically what's that saying is that copyright protection at a minimum level, in accordance with this title, Title 17, in original works of authorship fixed in any tangible medium of expression. So that's basically like writing it down, putting it on a software like Pro Tools 11, now known or later developed, from which they can be perceived, reproduced, or otherwise communicated, either directly or with the aid of a machine or device. Works of authorship include the following categories. So let me start right there. All right, so what it's saying, I'm gonna go over it again, break it down again. Copyright protection subsists in accordance with this title in original works of authorship fixed in any tangible medium of expression, now known or later developed. So what's that saying is that your copyright protection at a minimum level in accordance with this title, Title 17 of the Copyright Law of the United States, and any works that are recorded or written down on a tangible medium of expression, basically like a piece of paper. That's a tangible medium of expression. That's writing. Pro Tools or a computer. If it's on a computer, a laptop, it's tangible medium of expression. Pro Tools 11, it's recorded, right? If you record something in Pro Tools, if you record something in GarageBand, it's a tangible medium of expression. Now known or later developed, which is like Pro Tools 11, GarageBand, or later developed, which is something that will be later developed and you record something on there. So basically in the future, from which they can be perceived, reproduced, or otherwise communicated, either directly or with the aid of a machine or device. Works of authorship include the following categories. So basically, the copyright protection on any of those forms of any form of tangible medium of expression, it protects literary works, musical works, including any accompanying words, dramatic works, including any accompanying music, pantomimes and choreographic works, pictorial, graphic, and sculptural works, motion pictures and other audio-visual works, sound recordings, and architectural works. So what this next section basically says is that your copyright protection has limits on it. Now, the copyright protection, in no case does copyright protection for an original work of authorship extend to an idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied in such work. So it doesn't protect those things. It's not extended to those. It's not extended to any idea. So basically, what this section is saying is that your work is copywritten once you put it on a tangible medium of expression. Those, what I explained earlier. Now, to cross-reference that and to show you that, well, first of all, this is already a reliable source, but in a book called The Permission Seeker's Guide Through the Legal Jungle, Clearing Copyrights, Trademarks, and Other Rights for Entertainment and Media Productions, in section 3.1.3, copywriting your work, it says registration is not required. Now, of course, if you want to register your work with copyright.gov, you can. And as you can see, it's benefits to that. And one of the benefits that I like is it's easy to identify the copyright owner, which means it's easy to get business done. I know who you are. I can reach out to you. I want to use your work. You know, let me do business with you. Let's talk about, getting that the rights license and things like that. So so this section right here says registration is not required. Under the Copyright Act, any original work of authorship is copyrighted as soon as it is fixed in a tangible medium of expression. What it just said in the Copyright Act. Your work is fixed in a tangible medium of expression as soon as you write it down or record it. As a result, as soon as the writer jots a short story into a notebook, the poet types a haiku on the keyboard of a laptop computer, the composer hums a song into a tape recorder, or the filmmaker rolls the camera for scene one, a valid copyright is created. So basically, if you want that copyright, you don't gotta come out your pocket as soon as, like, if you don't want to spend that money on that copyright, you don't have to come out your pocket. You can save that money, keep that money in your pocket, but you need to go record it on something first, though. You need to write it down on something first. If it's a melody that you got in your head and you know what notes to write down, you know how to put the quarter notes together, the clef note, the sheet music, you can put that down, write it down. It needs to be on a tangible medium of expression. And once it's on that, it's copywritten. Your work is copywritten. So that's where I'm coming from today. Once again, my name is Clifton Williamson Jr. This is Liberating Intelligence, copywriting your work. Thank you. Much love. Peace.